Today's show is special. It's going to be a part of Operation Urban Grow. This is a grant that's being done by T.I.M.E and by Footprint Farms through the Socially Disadvantaged Farmers and Ranchers Policy Center located in Alcorn State University in Lorman, Mississippi. So shouts out to the Policy Center, and we look forward to this conversation that we're going to have today. Remember that ag and culture, we're very interactive. We want to hear from you. Touch us on all of our social media platforms. Reach us at footprintfarmsms.com. Hit us on Twitter. We're here for you. And of course, you know, ag and culture is all about exactly that. We want to dive into it, but how it affects Black people and farmers of color. So without further ado, I'm so excited to have in studio with me today none other than my good friend. I call her the queen of heirs property, Miss Ebony Woodruff. And before we get started, I just want to run down some pedigree about Ebony. She is currently the director of Southern University's Law Center Agricultural Law Institute for Underserved and Underrepresented Communities on the campus of Southern University, Baton Rouge, Louisiana. She's a first-generation attorney. She's a legal entrepreneur and a former legislator, which is something that, in doing my research, I'm proud to know that Ebony is the first woman elected to represent District 87 in the great state of Louisiana. So without further ado, Ebony, welcome to Ag and Culture. Glad to have you here.
Thank you for the invitation. Happy to be here and excited to have this discussion.
Absolutely. So as I mentioned in the opening, you know, Ebony and I met about maybe about 2 years ago now at some heirs property conferences, and I was like, who is this young lady right here? Because she seemed to have some really approachable answers to a really tough thing in heirs property. So Ebony, I'm gonna let you have the floor, just for those who may not be as fluent as we are in our everyday speak. Kind of speak to what is heirs property, and heirs property is spelled HEIR''S. So let us know what heirs property is and what issues as Black folks are we having with heirs property.
Okay, so heirs property is a legal term used to describe family land that is being passed down without a will. So either the original landowner did not have a will, or they had a will that was considered invalid for one reason or another. And so this is a problem because with each generation, the heirs increase. So generally each state will have laws that dictate how assets are passed throughout a family if the deceased person has passed and they didn't have a will instructing, you know, how they wanted their assets to be distributed.
Right.
And so in Louisiana, we call it an intestate succession, meaning that the person died either without a will or a will that was not valid, and therefore the court was not able to, you know, uphold it.
Right.
And so when that happens, each state has laws in place. Usually they're pretty similar, but there's laws in place that will dictate. So in Louisiana, if a person dies without a will and they have children, then it automatically passes to the children. And they have an interest in the property. Technically, they don't own it. Right. And that's one of the main issues with heirs property is that the deed and all of the legal documents remain in the name of the original landowner. Right. And so until these families open succession and actually do the legal process of transferring ownership, they only have a legal interest. And so in a situation where perhaps a father died that had 4 children and he died without a will, then each of those children would have a 25% interest in that property.
Gotcha. A lot to unpack there. So, Ebony, in layman's terms, if I was left 1,000 acres by my late grandfather, and everybody knows that, yeah, he left this, but there is no legal documented instrument showing that. Number one, how much of a problem is that we're finding ourselves into, which it sounds like this is usually the typical thing that I'm sure that you hear, that, you know, well, granddad or grandma left us this land and it's ours. And when the chips are down and the legal documents are presented, then they may not have any recourse. So can you just kind of, am I on the right path with that?
You are 100% correct. And so it's an issue because even though you may have had these verbal conversations with your grandparents and granddad said, you know what, when I pass, I want the land to go to you. Unless your grandfather documented that in a will, a valid will, then unfortunately, that is not the way that it's going to go. And so in your situation that you described, if it was your grandfather, so depending upon how many children your grandfather had, whether or not those children are alive or if some of them are deceased, it dictates and determines how many heirs are involved. So in Louisiana, again, because I'm only licensed in Louisiana, so I'm going to be referencing Louisiana law, but depending upon if one of those original children of your grandfather, if they're alive or if they're deceased, if any of them have passed and they have children, then their children step up into their place and then they have a legal interest in the property. And then that creates a problem because in a few generations, 2 or 3 generations, you literally could have hundreds of people that have an interest in this property.
And in order to even get this like back in the family, you must contact all of those people that you just named.
Yes.
And it could get into the 20s, 30s, 50s, 60s, 100 people.
Yeah.
But however, to reclaim that land for whatever purpose, because at this point, depending on the state, it's probably in court. It's held up in the courts, right? The probate courts, right? Because now, because there is no will, and then we'll get to that, the importance of estate planning, that the state automatically takes it. And that's real. Am I over my skis on that? But is it safe to say that if somebody left me land and there is no recorded will or trust that says that's so, then the state says, wait a minute, we'll hold on to this till you guys can figure it out. Is that how it works? But even with that, is there limitations on that?
Okay, so the state doesn't necessarily take it, but because there's no will in place, if the family can't agree upon what they want to do with the land, then the state has laws that dictate how things go. For instance, usually there'll be one family member who's paying the taxes, who may be, keeping the property insured, cutting the grass. If storms come through, we're here on the Gulf Coast. If storms come through, perhaps there's this one family member that is doing the repairs on the property. So in a situation like that, because they don't actually own it, but they have a legal interest down the road, if the family is ever to straighten things out and get clear title to the property, then that one family member would have a legal right to seek reimbursement from the other heirs.
Right, and that's what
But you were correct.
No, go ahead. Go ahead.
No, I was going to say that you are correct that it creates a problem because when you have 20, 30, 40, 50, people that have an interest in it, you do have to contact all of them. So in a state like Louisiana, I don't know if we're going to get into the Uniform Partition of Heirs Property Act, but in Louisiana, we have not adopted that act. And so you have to have 100% buy-in. So if there are 100 heirs, you have to contact each heir and, get their approval to do anything, to get a mortgage, to lease it. If there's timber on that land and you want to enter an agreement to have the timber cut down, then you have to have the agreement of all of the heirs that have an interest in the property.
Yes, right, and again, I'm here in Mississippi, and I hear that more than none is that there's land that may be in an heirs property situation, but there are poachers that have come onto the property and have actually cut timber that did not belong to them one way or the other. And again, it goes back to, well, granddaddy left me 100 acres of this, and I'm just cutting what's mine. And what I think we have to realize is that, and the other thing you spoke about is that act. Can you just go back and talk about that act? You said that Louisiana does it. I believe Mississippi does participate in that act. Can you talk about that act?
Mississippi has. So it's the Uniform Partition of Heirs Property Act. And so this act was created by a group of, I know, attorneys for sure, one being Thomas Mitchell, who is basically, I guess, maybe like the grandfather of heirs property,
Right.
but himself and other heirs property practitioners. And so it was done to assist families that have heirs property. And so with the Uniform Partition of Heirs Property Act, it has several components that make it a little bit easier for families to straighten out these heirs property issues. So for instance, the 100% buy-in. You don't have to have 100% buy-in. I believe the threshold is 80%, which is still high, but it's less than 100%. Another highlight of this act is that it allows family members to have the first right of refusal. So that means before, the property can be sold to someone who's not an heir or not a family member, they do give the families the right to attempt to purchase the property, if they have the financial resources to do it. And then there are other things like enhanced notice. And so what that means is oftentimes, like you said, these land speculators, these developers who are specifically targeting heirs property, they have to go through a legal process, which again entails them contacting the heirs. I can say, as someone who does this work, the threshold for contacting them is a little bit low. Like in Louisiana, it usually entails sending a certified letter with, the pleadings indicating that, hey, this person is attempting to purchase the property and that it's going to be, auctioned on a certain date. So you would send that letter, but of course, sometimes the last known addresses of the heirs may not be their current address. And so technically, legally, if it is sent to that last known address that's on file, their job is considered done.
Right.
And then beyond that,
served at that
point. Exactly. And then the other thing I know in Louisiana is that they have to place ads in the newspapers. But I mean, in 2024, how many people are getting the newspaper and reading the classified ads to, see the legal notices? So those are some of the highlights. But again, you'll hear people refer to the UPHPA, which stands for the Uniform Partition of Heirs Property Act. And I believe currently it's been adopted in about 22 to 23 states. The great thing about it, from, I believe, Texas over to Florida, up into the Carolinas, if you look at it, there's a map. It's been adopted in pretty much all of the southern and southeastern states, except for Louisiana. But the great thing about that is that heirs property is predominantly in the South. And so the families can take advantage of that act.
Yeah, of that. Outstanding. We're talking to Ebony Woodruff. She is the director of Southern University's Law Center, Agricultural Law Institute of Underserved and Underrepresented Communities, based out of Southern Baton Rouge, as they say, down there in the swag Baton Rouge. As I think you guys are coming to Jackson this year, right?
Yes.
But Ebony, we've seen a lot of the horror stories that you just mentioned. The ads being put in the paper and no one's seeing it, and you've got family members who live there, and you get the sheriff's department knocking on the door saying you've got to get out. And the first thing people say is, well, I can show you all the receipts where I've been paying the taxes have been paid. Can you just speak to, just because you're paying the taxes does not excuse you from the whole issue of heirs property?
No. So again, you want to pay the taxes because heirs property is also vulnerable to tax sales. So again, oftentimes it's the one family member who's paying the taxes. Usually it's an elder in the family. And oftentimes what we see is that once they pass or transition, that the rest of the family member had no idea that, maybe that taxes needed to be paid or that this person was paying the taxes. And so that makes them, the property, vulnerable to a tax sale.
Right.
To speak to what you were saying, however, just because you are the person that is paying the taxes, it doesn't give you ownership to the land. It doesn't give you a greater ownership percentage or interest in the property. It pretty much only gives you the right to seek reimbursement from the other heirs for their fractional interest. So again, let's go back to if there are 4 children who have an interest in the property. And so they each have a 25% interest in this property. And so say there's the one sibling who is paying the taxes. Well, they technically are only liable for 25% of whatever that tax bill is. So say it's $1,000, then they technically would only owe $250. But if they're paying the entire $1,000, then they have a right to seek reimbursement from the other 3 heirs. And so then they each would be responsible for paying $250 to the person who's paying the taxes. So it gives you a claim in that regard. But in terms of feeling like, well, I'm paying the taxes so I can make the decisions or I can go out and mortgage this land or whatever. No, it does not give you that right.
Yeah, and that's the other thing that, we'll talk about the ethnic sensitivities of this, is that for folks of color, sometimes for us, the family dynamic, this person doesn't like this person, or this person doesn't like this person, and they'll say something crazy that, over my dead body or whatever before I sign something, or let this person, get land or whatever. Can you just talk about, for the people who may be going through that, just some of the ways you can alleviate some of those barriers? Maybe not all, but maybe a different approach to getting other family members to sign on to get this done?
So people may not be aware, but each state actually has an agricultural mediation program. And then even if your property is not rural, maybe it's not agricultural land, because there are also high incidences of heirs property in urban areas as well. There are mediators. So you can hire a mediator to come in and speak with the family. And so the mediator is a neutral party. They're not representing any particular heir, not even the heir that may have contacted them, for their mediation services. And so really, we just have to communicate with each other.
Sure.
And so we have to have these discussions, these family discussions, and it's okay, because there are going to be some family members who don't want to be involved, and that's fine. Just communicate that with the family members, and then there will be those who, have different ideas. But I think, one, you have to have a willingness to communicate, and then also, again, realizing that when so many people have an interest in varying ideas about what should happen, I think people have to be a little open to compromise, because ultimately the main objective is to keep these properties within the family. Oftentimes what we're looking at is, our great grandfathers who were able to acquire this land, during right after emancipation. And so think about all that they went through to acquire this property to pass down to us. And I think it's incumbent upon us to do whatever we can to ensure that we, are good stewards of the land, and that we maintain it for future generations. And so again, sometimes you may not get everything that you want. It may not always go the way that you want it to go. But I think, one, we have to be willing to have these open discussions and, compromise. But if it is a contentious situation, again, I think getting an outside party like a mediator involved to help the family have these discussions and, figure out who wants to stay in, who wants to be bought out, and then once you determine that, okay, then what are we going to do with the land? Are we going to put it in a trust, or are we going to, get it into agricultural use, and then, coming up with plans as to how are we going to split the proceeds, or how much is going to stay in to maintain the land and, keep things going. But communication is key, in all relationships. And so that's really the first step.
You mentioned, Ebony, this could happen. We know that traditionally happens in mostly rural areas, but I just heard you say something important, and that's a part of the series we're doing with this grant opportunity through the Socially Disadvantaged Farmers and Ranchers Policy Center through Operation Urban Grow, is to let our urban growers know that urban landscapes are not immune to heirs property issues. Can you kind of talk about on the urban side, how that affects someone in the urban landscape?
Oh, so it's pretty much the same, but it's interesting to see how heirs property and gentrification are linked. And so a lot of major cities, the gentrification is really due to heirs property. Again, it's, here in Louisiana, in New Orleans, after Hurricane Katrina, a lot of family members had issues getting disaster relief funds because the property was heirs property.
That's right.
They didn't have clear title, and they weren't actually the legal owners of the land. And so they could not apply. And so, after the property sat for so long, and because, it was all over the city, then the city put in special laws to try to get some of the properties, renovated and back into use. And so I believe it's 18 months, if it was a blighted or vacant property, then, they started coming out and putting liens on it, because the grass is too high, or, it was a danger to the community because maybe, the roof had collapsed or whatever it was. So a lot of families lost the property that way. And then, people who were capitalizing on the situation were able to come in and buy these properties for pennies on a dollar. And so, whether it's areas like I hear a lot about Brooklyn or, here in New Orleans, but in a lot of the urban areas where there's heavy gentrification, if you do the study and the research, you'll see that those are also the areas that had a lot of heirs property. And so what's scary is that there's a study that has been done in a conservative estimate about the loss of the land. Agricultural land is $326 billion. And so then when we add in the urban areas, that number goes up into the trillions of land that, generational wealth that we've lost due to heirs property and some other issues, but primarily heirs property.
That was a mouthful. I didn't really link the two together. But when you talk about urban and you talk about gentrification and you talk about heirs property, I mean, you're absolutely right. It goes back to the traditional thing, Big Mama left me the house or left me the house with the land on it. And when you peel back the covers and you look at it, there's no legal instrument that's been filed to say that you're the rightful owner of this property. That's unfortunate.
Yes. And I know you had mentioned earlier that we would get into it, so I'm just going to jump on in.
Do it.
The cultural aspects of it. And so again, in doing this work, I meet people who are often like, well, why don't they just do a will? Why didn't they just do a will? Again, remember that our great-great-grandparents were, most of them, because there were some free people of color, but a lot of them were enslaved. Remember, we were not even able to read and write. So we definitely were not being taught the laws of this land. Also, when you look at a lot of traditional African spirituality, religions, just the relationship that we had with the land was quite different. We didn't see land as something to be owned because we didn't create it, God or, whatever, whoever they were believing in created this land. And so the relationship that we had with that, we were stewards. We took care of the land and the land took care of us. It wasn't something that we can own. So the ownership portion of it was very foreign. Also, we have to look at the fact that at those times in the late 1800s, early 1900s, African Americans, we could not attend law schools. And so there were no Black attorneys to provide legal services, to do a will for a family, to talk to them about estate planning. And, just because of the times and what was going on in the country, if there were any white attorneys who were sympathetic, they really couldn't provide the services. They'd probably run out of town or put out of business.
Now their life is in danger now. Their life is
Just
is in
like the
danger, just
freedom
like
riders,
allies would
you know?
be. Yeah, that's absolutely right.
Exactly.
Yeah.
And so those were some of the reasons why people didn't have wills.
Yeah, Evan, you just preached to it. It goes back to that 400-year head start. There's nothing like that 400-year head start.
Yeah.
But I think that there is definitely some light at the end of the tunnel. So, Ebony, we've talked about the horror stories of this and what could possibly happen. What can you say to folks to not get into that situation? How can we plan now? Because again, we're that generation now who we've been in our professions. We're coming back home. There's this land that's there. We want to utilize it in some form or fashion, and now we're coming back. So we don't have those problems right now, and it's better to have these conversations while all the parties vested involved that are still alive. And within sound body and mind, is it time to go ahead and put these things in place? Can you just speak to somebody out there that's listening? What should be one of the first things you should do and try to make sure this is not happening to your family legacy?
Okay, prevention is key. Estate planning. You are never too young. And you never know the hour. I know, again, as someone who has been doing estate planning for a very long time, no one wants to face, or a lot of people often don't want to face our mortality, but it's coming whether we acknowledge it or not. And you don't know when. It doesn't have to be, that you age and get sick, or you age, and maybe just pass peacefully in your sleep. People die every day, out on the road. You never know. You leave for work one day, you may not make it home that evening. We have natural disasters, all type of things happen. And so you need to be prepared, and you are never too young, especially if you have children, if you own property, if you have any type of assets, then you need to have a will, you need to have an estate plan. And so the number one thing, prevention is key. Even if your family has heirs property, I advise all of the current living heirs to go ahead and get a will. Because even if we're not able to straighten out the heirs property and get clear title before you pass, at least you have a will in place that dictates who your interest should be transferred to once we get there. If not, then, if you have 5 children, now they all step up and they are splitting in interest. And so prevention is key. Do the estate planning. But beyond the estate planning, if you already have heirs property, the first thing that I recommend is doing your family's genealogy. I also recommend doing that before you contact an attorney, because straightening out these succession issues can become very costly. And so some of the work, whatever you can do before you hire the attorney, it'll just help you to do that than having them do it, because of course they're going to be charging you for their services. And so doing the family's genealogy, and also recognizing who actually is an heir, because sometimes there are people who think they are an heir and they're really not. And so getting a clear idea of how many heirs are involved and who is actually an heir is the first step. And so something key that I suggest, I know we're in the middle of summer now, but at the end of the year, when the holidays come around, or even now in the summer when people are having family reunions,
cookouts,
and then of course Thanksgiving and Christmas, when we come together, at least bring a notebook and just ask everyone to write their contact information down, so that when you start doing this work, you at least have current contact information to, contact everyone and let them know what's going on and talk to them about what's going on.
Right. So, Ebony, I know that this could be a costly thing with heirs property and everything involved of getting it untangled out of that. And I know that a lot of us don't have the wherewithal to fight that financial battle to get this done. Can you share quickly some resources that are out there that, if nothing else, if people find themselves in this position, that may be able to help out, in a pro bono type way, get some legal advice on how to unweb this weave?
Yes. So one, take advantage of your local legal services. So you will have like here we have Southeast Louisiana Legal Services, but every county and parish should have some type of free legal aid, and they oftentimes will do wills and successions. So that's also an option. Reach out to your law school. So again, I'm at Southern University Law Center in Baton Rouge, but we often have free estate planning clinics where we come out to the community, we talk about estate planning, but we will do wills and some successions for free for family members. And so in addition to us, there are other law schools that are doing this. There are other nonprofits that do this. So the Centers for Heirs Property in South Carolina, I believe, they offer pro bono services. So there are a lot of institutions, whether it be a law school or a nonprofit organization or a public legal aid, that you can get some of the services for free. And then also there is the USDA and Congress implemented the there's an heirs property relending program. And so some family members would be eligible to borrow funds to pay attorney's fees if you need to get, a survey on the land, but anything that you need to do to get clear title, there is a program for that, but it is a loan program. So those funds have to be repaid. But just to let people know that it is an option that's available to them.
Yeah, and obviously in our travels in this circle, in this space, that we know that there are, several organizations and resources that are out there, but, we just have to make sure that, the everyday folk who are not in this speak like you and I every day will have some type of resource to at least initiate the call to start trying to get some help. Because like you say, the longer we wait on this, the sometimes the worse that it gets to unravel. And I'll just go back to when you said genealogy, just for some of my listeners, basically we're going to do an ancestry. Going back to your family tree to make sure that, first of all, the people who are claiming this are within the confines of your family history. So just wanted to clear that up, because I know some probably may hit me back and say, hey, the big word genealogy, what is that? So just know that when you see genealogy, we're just studying the genes and genetics, the DNA makeup of that family tree. So
yes. So what you're going to do is go to the original landowner who purchased the property. And then from there, it's very simple. So if granddaddy purchased it, he had 5 kids. So you're going to put your grandfather, then those 5 kids. And then for each of those 5 kids, you want a list of who their children were. And then basically just do that until you're at the current generation, which there may be multiple generations who are living at the same time. But you want to get it to a place where everyone who's living is, on there. And so basically that's what it is. And then things that you want to include would be certainly their dates of birth and death. Yes. So you can email me at ebony.woodruff@sulc.edu. And so that's Ebony with a Y and Woodruff, WOODRUFF @sulc.edu. Or you can contact, because we do also have an estate planning clinic. And so you can just go to sulc.edu and look at the tab with clinics and contact the clinic as well. But we do provide free wills, and in certain events, if it's a simple succession, then we can provide that service as well. But even if you don't live in Louisiana, feel free to reach out to me, and I'll look within my network and I'll try to put you in contact with an attorney in your state.
Ebony Woodruff, she is the director of Southern University Law Center Agricultural Law Institute for Underserved and Underrepresented Communities, and is a guru in heirs property. Ebony, I can't thank you enough for sharing that with us on the show. Won't be the last time. We'll take an even deeper dive to look at some of the more nooks and cranny complexities of this. But the main thing of it is we don't want this to fester. We want people to have protection that they need so that they can continue to protect the precious acres that we have left in the Black farming community. Ebony Woodruff, thank you so much. That's been all for Ag and Culture. We'll see you next time. We look forward to seeing you. Like us on Facebook, like us on all the platforms, like us on YouTube. Follow us. We've got a lot of these great snippets, just like you heard with Ms. Woodruff. We've got a lot of that for you and a lot more. We want to thank Operation Urban Grow and the Socially Disadvantaged Farmers and Ranchers Policy Center for making this grant available and to us. So until next time, I'm your host, LeGrand Elliott, Ag and Culture. See you next time.